Welcome back to everyone. Welcome back after the break. And now Professor Gaetano Carlizzi will be speaking on the theme, the scientific question of fact, free evaluation of evidence, and the proof beyond any reasonable doubt. Gaetano Carlizzi is a judge at the military court in Rome, Italy, and has been professor of legal hermeneutics at Bocconi University and theory of interpretation and legal argumentation in Naples. Now he is full professor of legal philosophy and has written extensively on evidence law and proof, legal epistemology, criminal law and criminal procedure. So he's an expert on the theme now addressed. Please.
Thank you, Carlo. Good morning, everyone. I'm very pleased to be here with you today and delighted to thank Professor Ferrer Beltran and his colleagues for their invitation and warm hospitality. This morning, I'm going to talk to you about the so-called paradox of expert testimony, which can be described as: how can the judge assess information provided by an expert at trial if he needs him precisely because of his own lack of specialist knowledge? So I'll begin by analyzing the leading principles of the evidential judgment, as well as the possible judicial approaches to the role of experts at trial, in order to establish which of these approaches best implements the principles. Then I'll go on to show that if the judge follows the best of these approaches, the paradox of expert testimony will be seen to be merely apparent. My presentation will be quite succinct, so I'm sure we will have plenty of time for questions. Sorry. Okay. In many contemporary criminal trial systems, the free evaluation of evidence and proof beyond any reasonable doubt form the leading principles of the evidential judgment. Both principles, hereafter PFE and PRD respectively, emerged in the English legal culture and were then imported into the American trial before finding their way into some continental legal system, especially the Italian one. Moreover, as we will see later, each of these principles, as such, requires a legislator and judge to realize a specific value. The PFE, so we are going to look at the historical outlines, emerged in England after the 13th century, when the trial by jury took the place of the medieval ordeal procedure. More precisely, it came to light in the 16th century, when jurors were no longer witnesses jurors, so they had no direct knowledge of the case. This trial system was then important in the USA, and in 1791, the PFE was introduced into France, where the Constituent Assembly also introduced trial by jury, thus replacing the evidential regime of statutory or legal proof with that of the intime conviction of the jurors. The principle ultimately spread to other countries in continental Europe, in particular in Italy, where Article 192 of the current Code of Criminal Procedure lays down that, quotation, the judge evaluates the evidence, setting out in the reasoning the results obtained and the criteria adopted. The PFE requires legislator and judge to realize two values, which, being interconnected, constitute the idea of judicial autonomy. The first one is the concreteness of the evidential judgment, namely its taking into account of all the particularities of the case to be ascertained. The realization of this value depends on the judicial freedom to select and apply the criteria for this ascertainment, so-called evidential criteria, and contrasts, in particular, with the already mentioned legal proof. The other value that the PFE requires to be promoted is the logicality of the evidential judgment, namely its being formally and materially consistent. The realization of this second value depends on the accord between the evidential judgment and the principles of logic and findings from experience, and is thus in net contrast with intuitive decision-making. The reason why I'm talking about these two values, in the case of the PFE and of another value in the case of the PRD, is that, in my opinion, the free evaluation and proof beyond any reasonable doubt form real principles and not simple rules. As you know, in the contemporary legal theory, there is a big discussion about the distinction between principles and rules. And to establish that there is a principle of free evaluation and a principle of reasonable doubt is very important, not only for theoretical reasons, but also for practical reasons, because the legislator on the one hand and the judge on the other hand has to follow these principles and to behave in a very specific way to avoid the constitutional court annul the statutes of the legislator or the Corte di Cassazione overturn the judgment of the judge. PRD2 emerged in England once again due to the introduction of the trial by jury, though the idea went by different names. In the 16th century, in fact, in order to find the defendant guilty, jurors were required to have a, quotation, satisfied conscience, and then in the 17th century, moral certainty. According to many scholars, the phrase proof beyond any reasonable doubt was used for the first time in an American judgment, in an American trial concerning the 1770 Boston Massacre. An attempt to provide a precise definition for this concept was made, again in the USA, in a judgment of 1850, a quotation of a very important passage of this judgment. Then, what is reasonable doubt? It is not mere possible doubt, because everything relating to human affairs and depending on moral evidence is open to some possible or imaginary doubt. It is that state of the case which, after the entire comparison and consideration of all the evidence, leaves the minds of jurors in that condition that they cannot say they feel an abiding conviction to a moral certainty of the truth of the charge. A certainty that convinces and directs the understanding and satisfies the reason and judgment of those who are bound to act conscientiously upon it. End of quotation. In the 20th century, the United States Supreme Court contributed to the further development of the doctrine of PRD in three ways especially. A. Acknowledging the constitutional rank of the principle, 1970 Winship judgment. B. Applying it in ascertaining not only the case, but, quotation, every element of the offense, as well as the circumstances influencing the penalty. And C. Trying to define the instructions to be given to the jurors for its application. In the same century, the PRD was explicitly established in a very few sources of international and national law. For example, Statute of the International Criminal Court, Article 66, and Italian Code of Criminal Procedure, Article 533. Nevertheless, according to some scholars, and in particular in my opinion, this principle may be inferred from some fundamental principles of international and national criminal justice. Specifically, it may arise either from the presumption of innocence or else from the due process of law. In my opinion, it may be inferred from this second principle, namely the due process of law, according to the Winship judgment too. Both established these principles, namely presumptions of innocence and due process of law, in the European Convention of Human Rights and Italian Constitution, among others. The value that the PRD requires a legislator and judge to realize is the optimal certainty of the evidential judgment, namely its developing in the strictest possible way. Its promotion depends on the observance of some epistemic and practical prescriptions, in particular, the method of the so-called eliminative induction, and it is in contrast with the preponderance of the evidence standard of proof and similar ones. I'm now going to address the possible judicial approaches to the role of the expert at trial in order to see which of them best implements both already mentioned principles. To make my overview more concrete, I will provide examples from Italian criminal case law. These approaches can be divided into two kinds. In simple terms, the judge can have either a closed or an open attitude towards experts. On the one hand, the judge has a closed attitude when he waives or contradicts the expert opinion, deciding in one of three alternative ways. All three approaches are consistent with the PFE's first requirement, that of concreteness, since the evidential criterion is freely chosen or applied by the judge. But none one of them is consistent with the PFE's second requirement, that of logicality, since the evidential criterion is either not at all scientific or not applied in accordance with scientific methods. Therefore, none of the three approaches is consistent with the PRD either, which demands the most rigorous application of scientific criteria. Let me now analyze these approaches. The first approach is that of the apprentice judge. He uses an evidential criterion, for example, a causal law or psychiatric notion, that is not at all scientific, but is only an assumption of common sense or even a vague stereotype. One example is a judgment of a Court of Appeal of Milan. The defendant, who plea bargained at one trial for robbery, was found to be a kleptomaniac by two psychiatrists in another trial, this time for theft. The Court of Appeal of Milan was petitioned to review the already mentioned plea bargain in the light of the psychiatric findings of the second trial. Therefore, the question of fact was whether the defendant had been mentally incapable not only at the moment of the theft, but also at the moment of the robbery. The Court of Appeal answered in the negative, ignoring the psychiatrist's opinion and referring to a fact, namely the ability to plan shown by the defendant at the moment of the theft, which has no scientific value. Indeed, not one of the most prominent psychiatry manuals, in particular the well-known Diagnostic Statistical Manual of Mental Disease, refers to this fact among the typical symptoms of the kleptomania. The second approach is that of the popularizing judge. I've chosen these names to make an ideology of the judge that evaluates the scientific evidence. The popularizing judge uses an evidential criterion that is not strictly scientific, but results from a trivialization or distortion of a properly scientific criterion. In this case, an example is a judgment of the Court of Appeal of Bari. The question of fact was whether the alleged victim of the crime of circumvention of an incapable actually suffered from senile dementia at the moment of the circumvention. The Court of Appeal answered in the negative, contradicting in this case the expert opinion and referring to the entry for dementia in a medical dictionary, namely a notion that has been established by scientists but only to satisfy the layman's general need for information. The third approach is that of the land surveyor judge. He uses an evidential criterion that is strictly scientific, but also so complex as to require specialist competence in its application. An example comes from a judgment of the Court of Appeal of Caltanissetta, which is a small town in Sicily. The defendant was charged with the crime of drunk driving. The question of fact was whether his blood alcohol level while driving was above the statutory threshold of 1.50 grams per liter. In fact, the blood alcohol levels ascertained about an hour after the defendant was stopped by the police were very close to the aforementioned threshold, 1.49 and 1.35 grams per liter. The Court of Appeal, applying the formula of the so-called Widmar curve, without the help of any expert, concluded that the threshold of 1.50 grams per liter had been passed while driving, albeit only slightly. In this case, the court used an evidential criterion that is actually shared by the expert community, but it is also formed by numerical and non-numerical variables that are too complex for the judge to quantify and coordinate. Conversely, judges show an open attitude when they take into account the expert opinion, deciding in one of two ways. In the first of these, the judicial approach is not consistent with the PFE, since the judge lets the expert impose the evidential criterion, so it is not consistent with the PRD either. In the second case, namely in the case of the second approach, on the other hand, the judicial approach is consistent with both PFE and PRD, since the judge shares the expert opinion only after seriously scrutinizing it. I'm going to look in depth at both approaches. The first approach is that of the Receptor Judge. He actually uses the evidential criterion proposed by the expert, but without questioning the epistemological reliability of this criterion and its application by the expert. An example is given by a judgment of the Naples Appeal Court of Assize. The defendant in this case was charged with the crime of murder for killing a public official whom he suspected had plotted against him. The question of fact concerned the defendant's degree of mental capacity. The appeal court shared the psychiatrist's conclusion on the partial capacity of the defendant, simply highlighting the, quotation, extreme precision and completeness of the expert report. However, the judicial conclusion was uncritical, as the Court of Appeal approved the expert opinion without explaining the actual grounds for its own assessment. The second approach is that of the Gatekeeper judge, a very famous phrase. He possibly uses the evidential criterion proposed by the expert, but only after verifying that it fulfills some specific requirements for epistemological reliability. The model of the Gatekeeper judge has been established by the very famous Daubert judgment, handed down by the United States Supreme Court in 1993, and it has been substantially shared by further national Supreme Courts, in particular by the Corte di Cassazione, in the 2010 Cozzini judgment. In the latter case, the defendant was charged with the crime of murder for having exposed a worker to asbestos dust, which can cause mesothelioma, among other illnesses. The question of fact concerned the so-called acceleration effect, an issue that is very controversial in the Italian case law, also at the present moment. The acceleration effect, this question concerning the acceleration effect is whether keeping a worker already affected by mesothelioma exposed to asbestos dust can accelerate the development of this illness and thus lead to early death. So the worker contracts the mesothelioma under the direction of a first defendant, but the second defendant keep him exposed to the asbestos dust, and the problem is whether this further exposure can accelerate the development of the illness. The question was resolved in the negative by the Court of First Instance and in the positive by the Court of Appeal. More precisely, the Superior Court said generically that, quotation, the acceleration effect is a finding that is constantly and undisputedly recognized in the scientific field, as well as being supported by illustrious and surely rigorous scientific publications. The Corte di Cassazione overturned the judgment of second instance, criticizing the approaches of both trial judges, which corresponded to the model of the Receptor Judge. Indeed, both trial judges, quotation from the judgment of the Corte di Cassazione, limited themselves to substantially transposing the opinion of an individual expert without interacting with him and playing the critical role of gatekeepers of the scientific method, end of quotation. In particular, according to the Corte di Cassazione, the judge behaves as a gatekeeper when he checks whether the expert opinion fulfills specific requirements. Which are very similar to the Daubert requirements, even though more numerous than the Daubert requirements. On one hand, there are subjective requirements which correspond to certain qualities in the expert at trial, as well as the scientist who elaborated the theory underpinning his opinion, namely identity, undisputed authority, independence, and pushed aims. On the other hand, there are objective requirements which correspond to certain qualities inherent to the already mentioned theory, namely its scope, precision, and objectivity, its degree of empirical corroboration and explicative capacity, as well as the intensity of the external discussion regarding the theory. Lastly, I'll try to show that if the judge becomes a gatekeeper of the scientific information at trial, the paradox of expert testimony will be seen as merely apparent. Indeed, when the judge behaves in this way, he expresses a meta judgment that is capable of making to a sufficient degree. More precisely, on the one hand, while the expert at trial asserts the scientific validity of the evidential criterion he puts forward, namely its operation in the real world as known by science, the judge checks the reliability of the expert assertion, namely that it fulfills the requirements mentioned before. On the other hand, while the expert assertion presupposes specialist competence that the judge actually lacks, the judicial check presupposes philosophical competence, namely competence of philosophy of science, that the judge normally has or can achieve. Briefly, while the expert opinion is an epistemic judgment, the judicial assessment of this opinion is an epistemological judgment. Ultimately, the logical hierarchy and the different conditions inherent to the two judgments are exactly the reasons why the judge is actually capable of assessing the expert opinion, so that the paradox of expert testimony is merely an apparent one, at least in abstract. Of course, these findings are only a starting point and not an arrival. In fact, they leave open many questions, which I like to propose for discussion. First question: are the previously mentioned requirements for epistemological reliability really useful in every specialist and not only scientific evidential question? For example, can they be applied in order to ascertain why a tire exploded, as in the very famous Como tire case, or whether a painting was really created by the artist who signed it? The question arises since the evidence considered in both Cozzini and Daubert judgments belongs to the natural sciences, biology, oncology, epidemiology, and so on, which are pretty different from other kinds of specialist knowledge. Second question: can these requirements be applied also when the expert opinion to assess belongs to a pluralistic discipline? By pluralistic discipline, I mean an organic body of specialist knowledge that is not monopolized by a unique school of thought, but shared between different doctrinal approaches, where none has been able to prevail over the others, and each relies on assumptions that are at least partially incompatible with those of the others. For example, a pluralistic discipline is the psychiatry. In fact, psychiatric diagnosis on the mental condition of an individual can be made according to many approaches, which are in principle equally valid. The neo-positivist approach of the already mentioned DSM, Diagnostic Statistical Manual, and the phenomenological approach of the Allgemeine Psychopathologie of Karl Jaspers, and so on. Well, how is the judge to behave if three experts at trial, referring to these different approaches, conclude that the defendant is fully capable, half capable, and totally incapable, respectively? The point is that most of the requirements for epistemological reliability established in both Cozzini and Daubert judgments seem to be here of scarce utility. Indeed, in this case, unlike in Cozzini and Daubert, we are in the presence of no competing science and pseudoscience. No earthquake. We are in the presence of no competing science and pseudoscience, but of approaches based on theoretical and ideological points of view that are different and to some extent even incommensurable. Third question: how can we describe the working logic of the requirements for epistemological reliability? In my opinion, this is probably the most interesting question about the evaluation of epistemological reliability of the expert. Well, in my opinion, it is not a binary, but a gradable logic. Indeed, on the one hand, it's impossible to define the epistemological reliability in terms of a set of necessary and sufficient conditions. For example, even the general acceptance by the specialist community is irrelevant if this community is a gang of quacks. On the other hand, every requirement for epistemological reliability can be, in turn, fulfilled to a greater or lesser extent. For example, a scientist can be more famous than another. This working logic, this gradable working logic, implies that the judicial evaluation of expert evidence is flexible and demanding. For example, although an opinion has been proposed by an expert who is not wholly independent, it may be thought highly epistemologically reliable by the judge, as it relies on broad experimental research and is shared by the majority of scholars in the field. Fourth question, and last question. To what extent must the requirements for epistemological reliability be fulfilled for proof to be beyond any reasonable doubt? The issue arises because the beyond any reasonable doubt barred standard of proof regulates the probative sufficiency of all the collected evidence and not a single item such as each expert opinion. Nevertheless, as seen above, the PRD, the principle of reasonable doubt, in general terms, demands optimal certainty of the criminal proof. Therefore, the barred standard has to influence every stage of the evidential judgment, including the evaluation of epistemological reliability, and the judge may consider an expert opinion true only if it is fully reliable. On the other hand, it's not clear what the phrase finding an expert opinion reliable beyond any reasonable doubt exactly means. According to the approach of the already mentioned American judgment of 1850, which is current in the works of many scholars, who give a methodological definition of the concept of proof beyond any reasonable doubt, the phrase finding an expert opinion reliable beyond any reasonable doubt should mean a simple state of mind of the judge. Quotation of the judgment, as you remember, a certainty that convinces and directs the understanding and satisfies the reason and judgment of those who are bound to act conscientiously upon it. This is a simple state of mind, and in my opinion, this substantial definition or material definition of the concept of proof beyond any reasonable doubt is mere tautological. Namely, it says the same thing it has to define without giving further information. In my opinion, this approach is disputable since it doesn't provide a clear guidance for the judge in applying the barred standard. The concept of finding an expert opinion reliable beyond any reasonable doubt should rather be defined in methodological terms, namely in the light of the method of the eliminative induction, which, as seen above, is the epistemic core of the PRD. More specifically, the judge may consider an expert opinion as reliable, or better, as fully reliable, namely, as reliable beyond any reasonable doubt, if he a. verifies to a high degree the most important features that occur when opinions of this specific kind are deemed true, so-called positive features, for example, general acceptance by the specialist community. The problem is that these features can be established once for all, but has to be established for every kind of expert opinion. B, the second step of the judicial check, the judge has to have good reasons to believe that the possible weakness of remaining positive features as well as strength of negative features has a neutral significance. For example, the expert appears to be highly partisan as he works for a company whose CEO is the defendant, but the employment contract is expiring in a week's time. Sorry. Thank you very much for your kind attention.